Our second speaker is Mr. Andrew Lowenstein. Lowenstein is a partner of one of the most prestigious law firms, Foly Hoag, and served as a counsel for many international law cases, including the famous South China Sea case. Mr. Lowenstein will deliver a presentation entitled "The Peaceful Settlement of Disputes Concerning Due Diligence Obligations under UNCLOS." Mr. Lowenstein, you have the floor.
Thank you very much. It's a pleasure to participate in today's panel and to speak alongside, if only virtually, such distinguished colleagues. As was mentioned, I am an international law practitioner, and my practice focuses on representing states in disputes before international courts and tribunals, including frequently disputes concerning the interpretation and application of UNCLOS. Many of these cases have involved claims concerning the protection and preservation of the marine environment. So I am thrilled that the organizers have chosen regional cooperation and marine environmental protection under UNCLOS as the theme for this year's conference. And I am especially delighted that they have included a session on the peaceful settlement of marine environmental disputes. In fact, I would suggest that few topics are more timely. Although for decades, international courts and tribunals have adjudicated precious few environmental cases, and even fewer concerning the marine environment, that's changed. Environmental disputes, including disputes concerning environmental obligations under UNCLOS, now frequently appear on the international docket. Today, I would like to focus on how international courts and tribunals have addressed one important subset of those disputes, specifically cases concerning the obligation of due diligence, including especially environmental impact assessment, or EIA. But before proceeding, I should make the customary disclaimer that since I will be discussing cases in which I served as counsel, the views I express are my own and should not be imputed to anyone else, including the parties I represented. EIA is the process by which projects, prior to their implementation, are evaluated to determine their likely impacts to the environment. It's a planning tool that assists the project proponent and the regulatory authorities in making decisions such as where the project should be sited and how it should be designed so that potential adverse impacts can be eliminated, reduced, or mitigated. Although the customary obligation to carry out an EIA appears to have crystallized relatively recently, it's rooted in the well-established principles of due diligence and prevention. The ICJ has long recognized that customary international law relating to the environment obligates states to use all the means at their disposal in order to avoid activities in their territory causing significant damage to the environment of another state. As the court put it in the pulp mills case, due diligence and the duty of vigilance and prevention, which it implies, would not be considered to have been exercised if a party planning works liable to affect the regime of a river or the quality of its waters did not undertake an EIA on the potential effects of such works. This general principle, of course, extends to activities that can impact the marine environment. ICLOS's Seabed Disputes Chamber, in its 2011 advisory opinion concerning the area, stressed that the obligation to carry out an EIA is both a direct obligation under Article 206 of UNCLOS and a general obligation under customary international law. The same point was repeated by the tribunal in the South China Sea arbitration, which emphasized that UNCLOS ensures that planned activities with potentially damaging effects may be effectively controlled and that other states are kept informed of their potential risks. States are increasingly turning to international courts and tribunals to adjudicate disputes concerning due diligence, including such matters as whether a transboundary EIA may have been carried out or should have been carried out, whether an EIA, in light of the characteristics of the project and the sensitivity of the receiving environment, was adequate in scope and content, and whether the project's ultimate location and design satisfactorily addressed risks evaluated by the EIA. To date, international state-to-state cases involving EIAs have concerned a wide array of activities ranging from nuclear fuel reprocessing to dredging to land reclamation to the construction of transportation infrastructure. The types of potentially impacted environments have been equally diverse, with riverine and marine ecosystems often the subject of international cases. As the evolving jurisprudence makes clear, the essence of due diligence is the evaluation and treatment of risk. Determining whether due diligence obligations have been breached, therefore, often centers on whether a state has failed to discharge its duty to evaluate and respond to risk, either by not undertaking an EIA at all, or by failing to do so adequately, or by failing to take appropriate measures to address risk. Whether the state's alleged failure resulted in actual transboundary harm is thus irrelevant. In some sense, this makes litigating due diligence-based claims less burdensome than claims for transboundary harm. States not required to establish that harm occurred, nor must it prove a causal link between the respondent state's alleged delinquency and the harm it allegedly caused. Moreover, by putting its claim in terms of EIA, a claimant may challenge the respondent state's allegedly delinquent actions before harm has materialized, or indeed prior to the implementation of the project. The claimant can thus seek to influence the project through the adjudicative process. Nonetheless, the challenges of litigating such cases are complex, and I will focus on two aspects in particular: the interplay between the fact-finding and decision-making processes at the domestic and international levels, and the means by which international courts and tribunals have dealt with the highly technical evidence that EIA cases often involve. I'm cognizant of the time, so I will say only a few words about the legal obligation itself. As a regulatory tool, EIA began in domestic laws and dates to 1969 with the enactment by the United States of the National Environmental Policy Act. Other states soon enacted their own EIA requirements. The acceptance of EIA is reflected in Principle 17 of the Rio Declaration, which refers to EIA as a national instrument that must be undertaken for activities likely to have a significant adverse impact on the environment. Parallel developments on the international plane closely followed, including the codification of EIA obligations in widely ratified multilateral treaties. For instance, in regards to the marine environment, Article 206 of UNCLOS requires that states, as far as practicable, assess the potential effects of activities on the marine environment when they have reasonable grounds for believing that planned activities may cause substantial pollution of or significant harmful discharges or changes to the marine environment. This obligation is particularly significant because it pertains to any activities that could significantly impact any part of the marine environment, even if confined to a state's own national jurisdiction or falling outside the jurisdiction of any state. I'll just mention a few of the other major conventions that also codify EIA-related obligations and which may have particular relevance for disputes concerning the marine environment. These include the ESPU Convention on EIA in a transboundary context, which establishes a detailed EIA regime in Europe, the Biological Diversity Convention, and a host of regional conventions, including treaties governing the protection of the marine and coastal environments of West Africa and Central Africa, the Red Sea and Gulf of Aden, the South Pacific, the Southeast Pacific, and the Baltic Sea. The dispute settlement procedures in UNCLOS have been the most frequently invoked. ICLS has had two such cases. In the Mox Plant case, Ireland sought provisional measures in relation to its claim that the UK had failed to adequately assess the effects of a mixed oxide plant on the marine environment in the Irish Sea. In the land reclamation case, ICLS was called upon to address EIA in the context of a provisional measures request made in connection with claims by Malaysia that Singapore had failed to assess the environmental impacts of a land reclamation project. China's alleged failure to carry out an EIA in regard to artificial islands it has built on submerged coral reefs in the South China Sea numbered among the claims that the Philippines asserted before a tribunal constituted under Annex 7. Adjudicating due diligence claims presents certain challenges, including having to judge against the standards imposed by international law, the scientific analyses and decision-making of domestic regulatory authorities. This can arise in disputes over whether an EIA was required for a project. And I should point out that not all EIA cases present this issue. For instance, in the pulp mills case, Uruguay did not dispute that it was required to evaluate the risks that the proposed pulp mills posed to a shared watercourse. Nonetheless, cases concerning whether a project requires EIA sometimes do arise. The process for determining whether a project must have an EIA is known as screening. In pulp mills, the ICJ articulated the threshold imposed by international law for requiring EIA as there being a risk that the activity may have a significant adverse impact in a transboundary context. Although some EIA regimes, such as the one established by the ESPU Convention, require EIA for certain listed types of projects, determining whether the threshold of risk is significant and has been crossed is often highly specific and often requires what's referred to as an initial environmental examination or preliminary environmental assessment. In the South China Sea arbitration, the Philippines argued that China had failed to carry out EIA for its artificial island building project. Tribunal thus had to determine whether the threshold for carrying out an EIA had been crossed. In the circumstances, the tribunal determined that the scale of the project was sufficient to trigger the obligation to perform an EIA, given that it could destroy directly reef habitat, indirectly impact coral and seagrass habitats, and further indirectly impact living organisms in the water column. The ICJ took a similar approach when deciding whether Costa Rica's construction of a highway adjacent to a Nicaraguan river required an EIA. The court held that whether the project poses a sufficiently serious risk so as to require an impact assessment should be evaluated objectively and by reference to the nature and magnitude of the project and the context in which it is to be carried out. The court thus took account of the fact that the scale of the road project was substantial It also noted that because the road's planned location was immediately next to a Nicaraguan river, any harm to the surrounding environment could easily affect the river and therefore Nicaragua. And in evaluating whether this risked significant transboundary harm, the Corps explained that it had to take account of the geographic conditions of the river basin where the road was to be situated. It noted that not only would the road traverse a Ramsar site in Costa Rica, it would also be located next to a Nicaraguan Ramsar site. These Ramsar sites increased the risk of significant damage because they indicated the receiving environment was particularly sensitive. The heightened due diligence obligation for marine sites of a similar nature is codified in paragraph 5 of Article 194 of UNCLOS, which stipulates that the measures taken in accordance with the environmental protection obligations set out in Part 12 must include those necessary to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species or other forms of marine life. As I mentioned, most disputes concerning EIA center not on whether an EIA was required, but rather on whether an EIA was adequate in scope and content. The process for determining what an EIA should cover is known as scoping. Scoping is largely a function of a state's domestic laws. As the ICJ held in pulp mills, it's for each state to determine in its domestic legislation or in the authorization process for the project the specific content of the environmental impact assessment required in each case. However, states do not enjoy complete discretion in determining an EIA's content. International law also plays a role, and it requires that EIA have regard to the nature and magnitude of the proposed development and its likely adverse impact on the environment. Regard must be had as well to the overarching need to exercise due diligence in conducting the assessment. As the ILC commentary put it, the standard of due diligence against which the conduct of the state of origin should be examined is that which is generally considered to be appropriate and proportional to the degree of risk of transboundary harm in the particular instance. Thus, activities which may be considered ultra-hazardous require a much higher standard of care in designing policies and a much higher degree of vigor on the part of the state to enforce them. The ICLS Seabed Disputes Chamber put the concept well when it observed that due diligence is an inherently variable concept that may change over time as measures considered sufficiently diligent at a certain moment may become not diligent enough in light of, for example, new scientific or technological knowledge. Nor can EIA be an empty formality. Due diligence requires that its conclusions be taken into account in how the project is implemented. This can take a number of forms, including measures to avoid, prevent, or mitigate adverse impacts by, for example, altering the project's scale, design, or siting, or by requiring appropriate management, monitoring, or auditing. As ICLS has observed, the obligation to act with due diligence entails not only the adoption of appropriate rules and measures, but also a certain level of vigilance in their enforcement. The state must therefore take appropriate actions to detect impacts and to enforce compliance with the regulatory measures that have been imposed. Disputes can arise over any of these aspects of EIA, and their adjudication requires the court or tribunal to evaluate the sufficiency of a state's regulatory actions in a manner that requires it to address issues that are fact-intensive and highly technical. This can be challenging. Not surprisingly, parties often disagree about the underlying scientific evidence and its import. 7 judges on ICLS could have been describing any number of cases when they observed in a joint declaration in the Mox plant case that Ireland's dispute with the UK was characterized by an almost total lack of agreement on the scientific evidence with respect to the possible consequences of the plant's operations on the marine environment. Some judges have expressed a degree of unease about their ability to resolve highly technical issues. In the pulp mill case, Judge Alcassane and Judge Sima observed that this exceptionally fact-intensive case, and that was their characterization of it, was unlike most cases submitted to the court and raised what they considered to be serious questions about the role that scientific evidence can play in an international judicial institution. And they expressed concern that what they called the traditional methods of evaluating evidence were deficient in assessing the relevance of such complex technical and scientific facts. And it's perhaps for that or similar reasons that sometimes there's been a preference for relying upon, where possible, the conclusions of independent experts. In the land reclamation case, after ICLOS determined that Singapore had not assessed the project's impacts on waters under Malaysian jurisdiction and found that it could not exclude the possibility that it might adversely impact the marine environment, ICLOS ruled that the parties should establish mechanisms for exchanging information and assessing the risks or effects of the project and devising ways to address them. The tribunal therefore ordered the parties to cooperate and to study on agreed terms the reclamation efforts effects and to propose as appropriate measures to deal with any adverse impacts. The tribunal further directed Singapore not to conduct its land reclamation in ways that might cause irreparable prejudice to the rights of Malaysia or serious harm to the marine environment, taking into account the reports of a group of experts that would be assembled. Singapore and Malaysia ultimately settled the dispute when Singapore agreed to modify the projects based on the experts' findings. There is, however, a trend of international courts and tribunals becoming increasingly willing to engage directly with scientific evidence. This was on display, for example, in the hearings in the joint San Juan River cases before the ICJ. Not only were the parties' experts cross-examined about such complicated topics as fluvial geomorphology, hydrology, and the impact of sediment on aquatic biota, there is extensive questioning from the bench. No fewer than 9 judges posed sophisticated and nuanced questions. The tribunal in the South China Sea arbitration was particularly proactive in engaging with the scientific and technical evidence. Not only did the tribunal pose questions to the Philippines experts, the tribunal appointed its own team of scientific experts on coral reef ecology, which it commissioned to provide an independent review of the factual record, the scientific literature, and other publicly available documents. I think this optimistic note is perhaps a good place as any for me to stop. So thank you very much, and I look forward to what I'm sure will be a very interesting discussion.